Good morning to all of you. Today we are going to discuss a case law on section 211 of the Indian Penal Code. Nowadays, this section 211 IPC has got importance particularly in Andhra Pradesh due to the release of the film Nandi, wherein a police officer and the state will be prosecutor for innocently roping in a software engineer into a crime against a crime on an advocate. Of course, because it's cinematic, so many twists and turns will take place. But anyway, people are able to know what is section 211 of the IPC. Now, a good judgment has come on 211 IPC by Madras High Court. Of course, before that, you have to remember that every case depends on the facts and circumstances of the case. And 211, please remember, it reminds you or it gives the provision to file a private complaint or a private complaint against a person who normally who tries to rope in innocent persons. That is a false charge, we can say as a false charge of offense with intent to injure the damage or the reputation of any person. If anybody is falsely charged or if anybody tries to rope in a person, definitely as though he has committed an offense, then he is liable under section 211 IPC. Of course, the punishment is for 2 years. So, if at all anybody files a false case against you, you can go in that provision of law. Now, while disposing the single judge bench, Mr. Anand Venkatesh, while disposing the case of A.Radhika, she is an ex-DSP in CBCID, Madras, versus Wilson Soundarraj, 2020, in criminal OP number 2514 by 2020 on 26th of February, held that the charge of false accusation under section 211 IPC should be leveled against the person who gave the complaint. That means against the complainant. So there is a little difference. Complainant means on behalf of the criminal cases, the state will be the complainant, but de facto complainant, we can say. So the charge of accusation under section 211 IPC should be filed against the de facto complainant, but not the investigating officer. Here, the complainant, the appellant is Radhika, madam, is the DSP who investigated the case. Right. Now, if we go back into the details of the case, actually he is Mr. Wilson Soundarraj and another person by name, by two other persons. They were involved as accused in crime number 473 by 2002. 473 by 2002, registered under sections 120B, conspiracy, 307, attempt to murder, 450, 451, house trespass, being after committing house trespass armed with deadly weapons, 384 is nothing but extortion or blackmailing, and 506, intimidation, right, with that maybe 109, abatement. All these sections were booked based on the complaint given by Rajamani against Soundarraj and others. Right, the case was registered in F2 police station at More. Then, of course, it has become a sensational issue. After registering the case, the local police could not withstand the pressure. Ultimately, the case was transferred to CBCID. So, for which Mrs. Radhika, Madam Radhika, she was the DSP. She investigated the case. Yes, no doubt, she investigated the case and she has filed a charge sheet against the accused. At that time, Mr. Wilson Soundarraj, he is a complaint that he has filed a habeas corpus writ petition in the High Court of Madras as the police have illegally taken into custody some of the accused persons, and that caused the ire of the CBCID. Therefore, he was also lugged in as one of the accused. Right? Now, they filed the charge sheet. Of course, after examining the witnesses, after conducting the trial court, that is, I think, 24th Additional Session Judge of Madras City, he acquitted all the accused on 21/2/2006. During the year 2006, all of them have been acquitted. Of course, the police did not keep quiet. The CBCID filed an appeal in the matter, but of course, This matter was also dismissed on 22/6/2017. So, after 11 years of filing the appeal, the case was decided. Of course, the Honorable High Court also actually allowed the judgment of the trial court and acquitted all the accused. Right now, after coming out with clean hands, now Wilson Soundarraj, he filed a private case under Section 211 IPC, alleging that it was malicious prosecution. Right now, the Honorable Judge, since it is a case of private complaint, he has taken it on file, he has given the CC number, and actually you have to remember two sections in this correction. Actually, contempt of lawful authority, 195 CRPC. So, normally, if at all you want to punish a person for the contempt of lawful authority, definitely that too by a public servant, section 195 comes into existence. Normally, we file cases regarding the documents under 195 CRPC, right? But anyway, so the procedure will be enlarged, will be envisaged in section 340 of the CRPC. So when an application is filed under 195 CRPC, that a contempt of lawful authority has been done by a public servant, that means a public servant has filed a false case. Then the trial judge or the judge, he has to, if he is of opinion that it is expedient in the interest of justice, then he can give the summons and he can conduct the trial. Now the magistrate has given the summons, and this Radhika DSP who received the summons, she filed a case for returning back the summons or for the stay or 482 IPC, you know. Now the Honorable Court, taking into consideration of all these things, it has stated no doubt the case is acquitted. Acquitted on what? Because the prosecution failed to prove the case beyond any reasonable doubt. It's not the fault, right? Whatever it is, they are acquitted. Now they have come up with clean. The main point here is, suppose if who has filed a false charge against them. First of all, Mr. Rajamani, he has given a false report. If in the view of Soundarraj, he has given the report. So, basing on the report, basing on the evidence, the investigating officer collected evidence, he filed the charge sheet. Of course, because they are not able to prove in the court of law, they came out with the accuser came out with clean hands. So, if the that respondent Wilson Soundarraj thinks that he was falsely implicated, against whom he has to file the case? He has to file the case against Rajamani, the de facto complaint, not against the IO. IO has nothing to do with this. If you allow people to file cases against the IOs, the independence of the investigation will be jeopardized. That means people will not be that much of having guts to investigate in an impartial way. Definitely, normally, I told you, a doctor with the shivering hands or with the shaking hands cannot conduct the operation if he is under the impression that medical negligence case may be given against him. Like that, the investigation officer should be given a free hand. Moreover, if the respondent thinks that is malicious prosecution or false prosecution, definitely he can, malicious prosecution, yes, you know, it comes under tort law. Yes, definitely he can file a civil case or a tort case and get compensation for the mental agony he suffered. That's all, not against the IO. So, good judgment. It is useful for the police officers who see this video. Normally, as advocates also, whenever you have to support the police, please take this judgment and cite it. Very good judgment. Thank you very much.